Welcome to the course on medical law. This lecture will be about legal implications of medical malpractice. The concepts covered in this lecture are medical malpractice, impact of medical malpractice like erosion of trust, undermining professionalism, compromising patient-centered care, legal and ethical consequences, stigmatization of the profession, strain on healthcare system and the types of medical malpractice. The keywords of this lecture are medical negligence, medical malpractice, medical care, professionalism and patients' rights. The medical profession stands as a cornerstone of societal well-being, tasked with the noble responsibility of safeguarding and enhancing the health of individuals. Rooted in the tradition of compassion, knowledge and commitment to service, healthcare professionals played a pivotal role between science and humanity. This paradigm places the patient at the heart of healthcare decisions, emphasizing not only the treatment of ailments but also the holistic well-being of the individuals. Medical malpractice encapsulates instances where healthcare providers deviate from established standards of care, resulting in harm, injury or adverse outcome for the patients. Medical malpractice, when it occurs, can have detrimental effects on the reputation and nobility of the medical profession. While it is essential to recognize that the majority of healthcare professionals are dedicated to providing excellent care, instances of malpractice can erode public trust and tarnish the esteemed image of the medical field. So, medical malpractice means that the doctors owe a duty of care towards the patient. When he fails to take care of that duty of care, then it constitutes medical negligence. Many times, the words medical malpractice and medical negligence are interchangeably used, even in law. But medical malpractice signifies that there is an element of intent on the part of the medical practitioner. So, with an intention, he has decided not to do his duty of care towards the patient, which constitutes medical malpractice. In the context of India, a country with diverse healthcare settings ranging from urban hospitals to rural clinics, the challenges associated with medical malpractice take unique dimensions. The sheer scale and complexity of India's healthcare system, coupled with disparities in access and resources, contribute to complexity of addressing and preventing medical malpractice. So, India, we know, is a very vast country with diverse requirements, and the healthcare system, whether it is in private sector or in government sector, is not restricted to any specific discipline of medicine, but it covers modern forms of medicine, Ayurveda, Siddha and other traditional forms of medicine. So, handling medical malpractice in all these diverse healthcare settings is a real challenge. In India, hospitals or medical establishments exist both in private and public sector. So, this also adds to the complexity in addressing the challenge associated with medical malpractice and medical negligence. So, now let us see how medical malpractice impact the noble ideas of medical profession. Let us start with erosion of trust. Trust is the foundation of doctor-patient relationship. When patients experience medical malpractice, trust is shattered. This erosion of trust affects not only the individual patient, but also the broader community. People may become skeptical about seeking medical care, leading to often delayed treatment or even avoidance of necessary interventions. We know that there is a fiduciary relationship existing between the doctor and the patient. So, the patient often expects the doctors to adhere to their duty of care and the nobility of their profession. So, once they fails to do so, it leads to erosion of trust of the patient on the doctor. Let us see the second one, undermining professionalism. Medical professionals are held to high ethical standards, and the perception of malpractice undermines the professionalism associated with the medical field. Instances of malpractice can be seen as a breach of these expectations, affecting perceived nobility of the profession. Medical professionals are expected to adhere to high standards of professionalism. So, when they fail to do so, it shatters the public perception about medical fraternity. Third one is compromising patient-centered care. Patient-centered care, a fundamental principle of medical profession, emphasizes the well-being and preferences of the patient. Medical malpractice can shift the focus from patient-centered care to legal and defensive medicine, where practitioners may be more concerned about avoiding lawsuits than prioritizing the best interest of the patient. Now, let us see the fourth one, impact on relationship. The impact of medical malpractice extends beyond the doctor-patient relationship, and it affects relationships within the medical community as well. Colleagues may face increased scrutiny and distrust, leading to breakdown in collaborative and supportive environment, which is necessary for delivering optimal health care. We have to understand that a supportive and collaborative environment is necessary to provide optimal health care. But when there is a lack of trust with regard to medical malpractice or medical negligence, it often extends beyond the specific relationship the doctor and that patient had, and it extends to other persons in the medical community. Now, let us see the legal and ethical consequences. The legal consequences of medical malpractice can tarnish the professional reputation of healthcare providers. Being involved in legal battles and facing allegations of negligence can emotionally and professionally distrust, potentially leading to burnout and a negative impact on the mental health. So, allegations of medical malpractice or medical negligence can have significant effect in the emotional stability of practitioners in the medical profession. It is not only affecting the doctors, but also other persons in the healthcare industry. So, it can have legal and ethical consequences as well. Let us see stigmatization of the profession. High profile cases of medical negligence or malpractice can be sensationalized by the media, contributing to stigmatization of the entire medical profession. Such negative portrayals can overshadow the countless instances of exemplary care and dedication exhibited by the majority of the healthcare professionals. It can also lead out to strains on the healthcare system. Medical malpractice lawsuits and their associated costs contribute to overall financial burden on the healthcare system. These financial implications can divert the resources away from the patient care and necessary improvements in the healthcare infrastructure. So, this means that often due to allegations of medical malpractice and medical negligence, hospitals or other clinical establishments will have to invest in protecting themselves against such allegations. So, this requires extra care from their part in seeking the patient consent and to ensure that allegations of medical malpractice or medical negligence will not be successful in a court of law. But this often drains their resources and will significantly take away the resources which are required to improve the overall health infrastructure. So, medical malpractice in India can take various forms. It can include wide range of negligent actions or omissions by the healthcare professionals, which can lead to significant harm or injury to the patient. Let us start from sex determination. We have already seen in one of the lectures that sex determination is prohibited in India. It is also a punishable offence. So, whether it is preconception or prenatal sex determination of fetus, it is a punishable offence. But there are doctors and practitioners and clinics who engage in sex determination knowing that it is against the law. So, this constitutes a common kind of medical malpractice in India. Second one is organ theft. Organ theft, you might have heard about several instances of such allegations being reported in the media. There is already legal framework to regulate organ transplantation. Apart from that, there are professional guidelines as well as state guidelines which are binding upon doctors and clinical establishments who are capable of doing organ transplantation. But sometimes violation of these norms happens, which constitutes organ theft, which is a punishable offence in India. Third one is refusing treatment. So, you know that in India, clinics and medical establishments are existing both in the public and the private sector. So, in private sector, they will expect that the patients will bear the cost of treatment. So, their operation is also based on profit motive. But if the patient is unable to make the payment, then many times there are instances of treatment being refused to them. Sometimes this can happen even in public hospitals as well. But refusing of treatment is also considered as a common form of medical malpractice. Third one is fake documentation. Giving fake certificates like medical certificates for taking of leaves, whether it is in public sector or private sector, is a common form of medical malpractice. Creation of fake documentation is punishable offence under specific statutes as well as under the Indian Penal Code. But many times medical malpractitioners have been reported and they have been alleged to have made fake documents which constituted offence under the law in India. Third one is procuring patients through agents. This is also another common form of medical malpractice where patients are enticed to go to a hospital for treatment or approach a specific doctor for treatment. So, this happens either by way of advertisement or through other actions, but this is also a common form of medical malpractice. Next one is commercial surrogacy practice. In one of the lectures, we will be discussing in detail about surrogacy and assisted reproductive techniques. Commercial surrogacy is prohibited in India. So, but there are also clinics and hospitals who provide commercial surrogacy practice, which is prohibited. So, this is another common form of medical malpractice. Another one is disclosing the secrets of the patient. The medical information of the patient has to be kept as secret because every person has a right to secrecy under the constitution, which the law in the country has guaranteed. So, disclosing the medical information of the patient will also constitute medical malpractice under the law. Now, let us go forward and discuss each of these types of malpractice in detail. Sex selection. Prenatal sex determination test should never be conducted with the aim of terminating the life of a female fetus unless justified by unequivocal medical reasons outlined in the Medical Termination of Pregnancy Act of 1971. Section 23 of the Preconception and Prenatal Diagnostic Techniques Act 1994 provides punishment for any registered medical practitioner who performs or causes to perform the selection of sex before or after the conception shall be punished with imprisonment for 3 years and fine, which may extend to 10,000, and for a subsequent offence imprisonment for 5 years and fine up to 50,000. So, this means that prenatal sex determination or termination of life of a female fetus after identification of the sex, except as provided or permitted under the Preconception and Prenatal Diagnostic Techniques Act of 1994, is a punishable offence in India. It is completely prohibited. So, prenatal sex determination is completely prohibited, and even for termination of life of a female fetus, the due procedure and the conditions prescribed in the law. The applicable law is Preconception and Prenatal Diagnostic Techniques Act of 1994 has to be adhered. Non-compliance with this legislation is a punishable offence in India. Now let us see organ theft. Organ theft is act of taking a person's organ for sale without their valid consent. Most cases of organ theft involve coercion and undue influence on people living in poverty. Medical surgeons or doctors willing to break the law or ignore regulations, organ brokers and other intermediaries causes serious health issues for the society. Transplant commercialism involves cross-border organ trading, and thus transplant medical tourism comprises patients travelling beyond borders to sell their organs. In India, organ transplantation of human organs are governed under the Transplantation of Human Organs Act of 1994, which is a regulated activity. So, transplantation of human organs in India requires compliance with Transplantation of Human Organs and Tissues Act of 1994, which provides the regulatory requirements that has to be followed by clinics before performing organ transplantation surgery. But many times there are people who are engaged in practice of harvesting organs by undue coercion or undue influence or by offering of financial payment. All of this vitiates the consent and constitutes offence under the Transplantation of Human Organs Act of 1994. We have to understand that even if a consent letter is obtained, if it is established that the consent is obtained by coercion or by undue influence or by payment of a monetary compensation, then the consent is invalid under the law and it will constitute an offence under the Transplantation of Human Organs Act of 1994. Apart from this specific legislation, the provisions in the Indian Penal Code may also apply if some grievous hurt is caused or death is caused to the patient due to organ transplantation. Now let us see refusal of treatment. A doctor can refuse to treat the patient only if he is incompetent to provide specialized medical care to the patient. In all other situations, doctors owe a duty to care to the patient. As per Indian Medical Council regulations of 2002, no doctor should arbitrarily refuse to treat their patient. There is also one case, Dr. Sarosh Mehta versus General Manager Central Railways. The court held that providing medical aid in emergency situations is a service that cannot be denied. So, in such situations, irrespective of the capacity of the patient to make the payment, the doctor owes a duty of care towards the patient. Now, let us see fake certification. A doctor shall not provide a fake medical certificate. If any doctor produces or signs any untrue, misleading or improper medical certificate, he is liable to have his name removed from the register. In Dr. Neena Raisda versus Medical Council of India, which is a 2019 case, the Delhi High Court approved the warning and monetary penalty issued by the National Medical Commission, which was earlier the Medical Council of India, to the doctors for producing an untrue medical certificate. Use of untrue medical certificate or fake medical certificates is a very common practice for obtaining of leaves. But we must understand that providing of a fake medical certificate is a punishable offence in India, and it can also constitute medical malpractice, which is punishable under the ethical guidelines. And production of such forged documents will also constitute offence under the Indian Penal Code. Procuring patients through agents. Touts constitute one of the most interesting aspects of healthcare in India. I will give you a hypothetical situation. If you are in need of medical care, the agents of the doctor or the hospital will act as a middleman and appear from nowhere. They have a contact in high places and depending on your needs, they can arrange anything and everything. In lieu, they will take a commission either from you or from the doctor or the hospital. This is a common form of medical malpractice. In the draft National Medical Commission Registered Medical Practitioner Professional Contact Regulations of 2022, using online forums or agents for procuring patients will be considered as violation of the ethical rules and will attract penalty up to 3 months suspension of the license of the doctor. Now let us see commercial surrogacy practice. Commercial surrogacy refers to any surrogacy arrangement where the surrogate mother is compensated for her services beyond the reimbursement of medical expenses. So medical expenses can be paid to surrogate mother, which is perfectly legal. But if the payment goes beyond the medical expenses and it constitutes a financial payment for the services rendered by her, then it constitutes commercial surrogacy, which is prohibited under the Indian law. Doctors play an important role in the process of surrogacy. Thus, it is imperative to understand that doctors has to be more cautious while dealing with cases of surrogacy. The Surrogacy Regulation Act of 2021 banned various activities by doctors and surrogacy clinics like advertising or promoting commercial surrogacy. The surrogacy law bans commercial surrogacy and makes it non-bailable and non-computable offence to undertake commercial surrogacy. The commission of such an offence invites imprisonment for a term which may extend to 10 years and with fine which may extend to 10 lakh rupees. So, commercial surrogacy or other aspects of surrogacy will be discussed in detail in one of the coming lectures. But for the time being, let us understand that commercial surrogacy is prohibited in India and is also a punishable offence. So, both the medical practitioner and the persons who are operating the clinic will be responsible and will be liable to undergo imprisonment for a term which may extend to 10 years and fine which may extend to 10 lakh rupees. Disclosing the sensitive medical information of the patient. Maintaining the secrecy of patients in India is of paramount importance to uphold their privacy and protect the sensitive medical information. Healthcare providers, hospitals and medical professionals are obligated to implement robust security measures such as secure electronic health record systems, restricted access to patient information and regular training of staff on data protection protocols. Strict adherence to these regulations not only ensures the trust of the patient but also safeguard their personal health details from unauthorized access, fostering a secure and confidential healthcare environment in the country. So, medical records constitutes private information of the patient. So, sensitive medical information is coming within the privacy of the patient, which is a constitutional right guaranteed in India. So, the doctors have to take care that they are not doing anything which is compromising the secrecy of the patient, especially with regard to sensitive medical information. Sensitive medical information also constitutes data which is protected under the Data Protection Act, which was recently enacted in India. So, any compromising of the secrecy of the patient or disclosure of sensitive medical information will have serious legal consequences in India. Illicit relationship with the patient. Engaging in an illicit relationship with the patient is a serious breach of professional ethics in the healthcare fields. It is considered as highly unethical and is widely condemned within the medical communities. Such relationships compromise the integrity of the healthcare provider, patient dynamic, erode trust and can lead to significant harm. Maintaining clear professional boundaries is crucial for ensuring well-being and trust of the patient and upholding the ethical standards of the healthcare profession. According to the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002, it is a misconduct on the part of the doctor. Inferior medical devices. The use of inferior medical devices by the doctors refers to utilization of medical equipment or instruments that do not meet the accepted standards of quality, safety or efficacy in the healthcare industry. This can have serious consequences for the patient outcomes and safety. We have discussed in detail in one of the lectures about the standards required for medical devices in India. The Medical Device Rules of 2007 issued under the Drugs and Cosmetics Act requires that the medical devices or instruments used in diagnostics will have to follow the strict quality standards required in India. Doctors are expected to make informed decision when selecting medical devices for diagnosis, treatment or monitoring of patients. Inferior devices may lead to inaccurate dealings, faulty results or increased risk during medical procedures. To address these concerns, regulatory bodies in India such as Central Drug Standards Control Organization set standards for the approval and use of medical devices in India. To conclude, medical malpractice in India remains a critical concern that necessitates ongoing attention and systematic improvement. While the majority of the healthcare professionals in the country uphold high ethical standards, incidents of medical malpractice highlight the need for regulatory framework to enhance accountability. Addressing medical malpractice requires collaborative effort among healthcare providers, regulatory bodies and policy makers to strengthen patient safety measures, streamline reporting measures and ensure that ethical standards are consistently upheld in the healthcare industry. India's healthcare system can work towards minimizing instances of medical malpractice and, more importantly, enhancing the trust and well-being of the patients it serves. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.